Hello and welcome to the weekly legal news update. In this video, we are going to discuss important news from 1st August to 6th August 2022. But before we begin, we have an official Telegram channel where we post daily subject-wise MCQs, so you can join that from the link given in the description box. Now coming to the first important news, the Supreme Court has held that 100% reservation in scheduled areas is unconstitutional. In the case of Satyajit Kumar versus State of Jharkhand, the Supreme Court has quashed a notification which was issued by the State of Jharkhand in the year 2016, which provided for 100% reservation for local residents of the 13 scheduled districts of the state. In this case, the court has held that 100% reservation provided for the local residents of the concerned scheduled districts would be violative of Article 16, Clause 2 of the Constitution of India and affecting the rights of the other candidates of non-scheduled areas guaranteed under Part 3 of the Constitution of India. In this case, the Supreme Court has also relied on a Constitution Bench judgment of the year 2020 in the case of Chebrulu Leela Prasad Rao versus State of Andhra Pradesh, wherein a similar 100% reservation for scheduled tribes in Andhra Pradesh was struck down as unconstitutional. In second important news, the Supreme Court has held that mere use of words arbitration or arbitrator in a clause will not make it an arbitration agreement. In the case of Mahanadi Coalfields Limited versus IVRCL AMR joint venture, the court has held while there is no specific form of an arbitration agreement, the words used should disclose a determination and obligation to go to arbitration and not merely contemplate the possibility of going for arbitration. Where there is merely a possibility of the parties agreeing to arbitration in future, as contrasted from an obligation to refer disputes to arbitration, there is no valid and binding arbitration agreement. Lastly, the Supreme Court has directed SEBI to disclose documents used for filing complaint to Reliance Industries. In the case of Reliance Industries Limited versus Securities and Exchange Board of India, the issue was that SEBI had issued a complaint filed by S. Gurumurthy in the year 2002 and the regulator has initiated probe into the irregularities. When Reliance Industries requested for disclosure of the opinions and related documents, SEBI turned down the request. So in this context, the Supreme Court has noted that SEBI is a regulator and has a duty to act fairly while conducting proceedings or initiating any action against the parties. Being a quasi-judicial body, the constitutional mandate of SEBI is to act fairly in accordance with the rules prescribed by law. The role of a regulator is to deal with complaints and parties in a fair manner and not to circumvent the rule of law for getting successful convictions. The court has also said that there is a substantive duty on the regulator to show fairness in the form of public cooperation and deference. It is an important case on administrative law because the Supreme Court has also noted that duty to act fairly by regulatory authorities is tied with the principles of natural justice, wherein a party cannot be condemned without having been given an adequate opportunity to defend itself. With this, we come to the end of our weekly legal update for this week. If you like this video, please like and share and subscribe to our YouTube channel.